She's a bully. I'm telling you. She's a bully. She could keep being a bully if she wants to, but that is going to catch up to her.
You might remember this woman, Afeni Muhammad, the McDonald's employee who apparently went on a rant that prosecutors say turned deadly when she was accused of killing her manager at a McDonald's following an argument. Well, now a major decision has flipped this case, and we're going to break down what it means for what comes next in court with a criminal defense attorney. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. This all started with a rant. It was raw, it was angry, and it was all over Instagram.
She's a bully. I'm telling you. She's a bully. Somebody will have to do something about that. It's not funny. It's not fair. It isn't funny at all. So, she could keep being a bully if she wants to, but that is going to catch up to her.
So yeah, you might remember this woman, 27-year-old Afeni Muhammad, who we have talked about here before on Sidebar. That was her, apparently venting online about her manager at a McDonald's in East Point, Michigan. And hours later, that same manager, Jennifer Harris, was dead. And now, after months of silence and questions about what would happen next in this case, there is finally a new development that we have to talk about, one that clears the way for what comes next in court. Now, we're going to get to that, but first we got to rewind. This is one of those stories that actually started on social media, and it spiraled into something that no one could have imagined. On July 10th, police say that Afeni Muhammad, an employee at the McDonald's, a 9-mile road, got into some sort of argument with her manager, Jennifer Harris, after she said she was sent home early. According to investigators, Muhammad left, sat in her car for a while, and then came back with a knife. So when we talk about premeditation, let's think about that. When officers arrived, what did they find? Harris had been reportedly stabbed up to 15 times. A customer with a gun had stepped in to stop Muhammad from fleeing. Now, Harris was rushed to the hospital. She tragically died later from her injuries. Horrific case. And on July 11th, when we talk about what's going on in the court process, Muhammad made her first court appearance for her arraignment. This is where detectives laid out what they say happened in chilling detail.
Prior to the stabbing, Muhammad was sent home by Harris for not performing her work duties and told Harris, "I'll be back." Muhammad was arrested on scene and the knife was recovered. Muhammad admitted that she intended to kill Harris and stated that after she was sent home, she drove to a nearby park, decided to come back and stab Harris with a knife that she had inside of her vehicle. When Muhammad returned to stab Harris, she entered the back entrance with a hooded mask over her face in an attempt to conceal her identity and attempted to flee the scene after the stabbing, but was stopped by an armed customer.
So Muhammad was charged with first-degree premeditated murder and carrying a dangerous weapon with unlawful intent. Now, she's also been charged as a habitual offender. What does that mean? Well, it's a designation that stems seemingly from a prior stabbing conviction in Virginia. We're going to talk about that too. Her bond was also set at $25 million cash or surety. Strict conditions if she were to be released, so that includes GPS monitoring, drug and alcohol testing, no contact with the victim's family, and a ban on returning to that particular McDonald's. Now, if you're a fan of Sidebar, if you're a fan of what we do here at Law&Crime, then you know that we cover a lot of cases. And you might be wondering, how are we able to share so many clips with our followers in such real time, in such a fast fashion? Well, I'll tell you, if you're interested in getting content up there very fast, we use a platform called Opus Clip. This is an all-in-one AI editor that makes it easier and faster to cut, create, and upload videos across all social media platforms. Through the power of AI, Opus Clip automatically generates B-roll, it cleans up audio, and it reframes your videos for any platform. Opus Clip is so easy to start using. I'm going to show you how right now. All you got to do is go to opus.pro/sidebar. You sign up, you upload a video, and in just a few minutes, you will have tons of perfectly edited clips ready to go. So whether you're making videos for TikTok or Shorts or Instagram Reels, Opus Clip is your one-stop shop for getting your best content seen by more viewers across all these platforms with the press of just one button. And if you're wondering how good these AI edited videos are from Opus Clip, just look at our content here at Law&Crime. Our producers have used Opus to help us cut and share clips of some of our biggest trials, and we do it really, really fast. Look, at Sidebar, we know our listeners have a lot of opinions and ideas to share, and this is the most powerful tool there is to help you edit like a pro and grow your audience. So give it a try for yourself. Go to opus.pro/sidebar to start creating your own videos today. Now we got to talk about what happened at her next hearing on July 23rd. This is when Muhammad's defense attorney requested a competency and criminal responsibility evaluation. In other words, does she understand the legal process and what's happening?
And you're asking that this matter be adjourned for discovery, number one, and number two, you want it referred to the Forensic Center for Competency and Culpability, is that correct?
Yes, Your Honor. Counsel does request at this time that Mr. Muhammad be referred to the Forensic Center for the matter. It's my understanding that Ms. Muhammad herself personally objects to the referral at this time.
What is the factual basis that you rely on for the referral?
Your Honor, based upon my observations of the case and in reviewing the case, specifically the police reports, and then again my observations in interacting with Ms. Muhammad, I need to check those two boxes. Meaning, I need to make sure that one, she is competent to stand trial, and then two, that there's not an issue in regards to responsibility or culpability.
So this meant that the case would pause while doctors, evaluators, would determine whether Muhammad really understood her charges, whether or not she could assist in her own defense. We actually spoke with forensic psychiatrist Dr. Daniel Bober about what evaluators look for in these situations, what it really means to be competent to stand trial. This is what he had to say.
Competency is a moving target. You know, someone can be competent one week and they can be incompetent the next week. So in the United States, competency is determined by a U.S. Supreme Court case, U.S. v. Dusky. And essentially what that case says is that you have to have the ability to work with your attorney, to collaborate with them, and have a rational and factual understanding of the charges against you. So there are so many different reasons. I watched the Instagram video that she had posted prior to the incident, and you clearly have someone who has poor impulse control, is emotionally dysregulated, has escalating anger, repeated frustration, feels powerless over her situation, and feels that she's being subjected to this perceived injustice. There are so many different things here in the differential, and obviously I've never examined her, so I can't make a diagnosis, but I think about things like psychosis, a personality disorder, substance use, perhaps repeated exposure to trauma. And I think about delusions. I think about psychosis when I hear something like that. But again, there's just so much information that we would need. For example, was she treated for a prior mental health condition? Was she under the care of a psychiatrist? These are things I'd want to know. Talk to people that were around her in the hours and days prior to the incident.
Now, during this same period, we also learned that Afeni Muhammad had a prior violent conviction. In March of 2022, she pleaded guilty in Virginia to unlawful wounding injury, stab, wound, cut without malicious intent. Court records from Virginia that were reviewed by Click on Detroit show that Muhammad had stabbed her then boyfriend during an argument in 2022, later telling police, "I stabbed him, is he okay?" Now, she was sentenced to 4 years, but that term was suspended, so meaning she only served probation. Now it becomes a question, could that affect the current case? So now the case is back in motion after the results from the findings on her competency evaluation came in. And we're going to break down that report in a moment. But first, we got to get into all aspects of this case. So let me bring on somebody to talk about this, somebody I'm always happy to have on, criminal defense attorney John Day. John, thanks so much for taking the time to come back here on Sidebar to talk about what is a very strange and yet sad case. From a prosecutorial point of view, maybe even a criminal defense point of view, what do you think the strength of this case is? I mean, you have this social media post, you have a potential eyewitness who allegedly stopped the defendant. Talk to me about how strong you think the evidence is in this case.
I mean, the social media post, the eyewitness, those are all, if you're the prosecutor, you really, I guess it doesn't get much better than that. I mean, eyewitnesses, of course, are always subject to, the idea that what we see is not necessarily what really happened. There's always a lot of research on that. But if I'm prosecuting this, I feel pretty good about that. I mean, that's enough for me to keep going. And you're going to hope that a jury sees this the same way.
Now, we'll talk about mental health in a second, but looking at this, if we build up the narrative that she was angry at her manager, she had this, it was fuming for quite some time. But how does the law separate between, let's say, an emotional impulse, maybe in the heat of an argument, even though she allegedly stepped out, came back in, and premeditation? Or is it just a very, very thin line?
Well, premeditation can occur in an instant, and that's what prosecutors are always trying to convince a jury when they're asked to step down a charge in a homicide case. I mean, it's the premeditation, it's the what was going on in that defendant's mind, what was leading up to that. It could just be a snap decision, but in the right circumstances, you can have premeditation that occurs in that snap decision moment. And so it's the idea that there's a backstory. Okay, this is not just a chance encounter, road rage type homicide. There's a backstory. There's something going on. And if you're the prosecutor, you want to hammer that home for the jury. You want to say, look, this is what was building. It's like turning on a tea kettle, and eventually the steam explodes, and that's what was happening here. And so the prosecutors are going to look at the backstory. They're going to try to build it up. They're going to try to put a foundation together so the jury understands really why this occurred, even though it was, obviously it was a horrifying situation. In the eyes of the prosecutors, there's a reason that this happened, and jurors, we're going to explain to you why.
And from a legal point of view, how does a prior conviction like Muhammad's 2022 stabbing case out in Virginia, how does that influence either the current charges or potential sentencing if she's convicted?
Right. Well, clearly it's not happening in a vacuum. I mean, this is not a situation where it's an aberrational, at least in the eyes of the prosecutor, in the eyes of the state. It's not an aberrational thing. It's something that there's a history. She knows full well what happens when you take a blade to a human body. She's experienced that before. So at the very least in sentencing, it's going to play a huge role. And of course, a lot depends on what gets in, what the judge lets in front of the jury. But the idea that this is someone who's not, who has a familiarity with what happens when you take an instrument like that, a deadly weapon, and you apply it to a human body, in the eyes of the prosecutor, she fully knew what was going to happen.
Well, let's talk about this. So the defense, they requested this competency evaluation and a criminal responsibility evaluation. How often do we see that in the beginning stages of these cases, or maybe during the course of a case, right? Competency doesn't necessarily have to be an issue that happens right at the beginning. It could sometimes happen in the middle. How often do we see that?
Right. Well, generally, so what happens is in the judicial system, anyone who has a concern, generally it's the defense lawyer, but a judge can raise it, a prosecutor can raise it. Of course, that's much more rare, but defense lawyers have an obligation. If you think there's something going on with the client, with the defendant, that raises the issue of competency. And remember, competency is very different from things like, not guilty by reason of insanity, things like that. Competency is pretty narrow. It's just the idea that this defendant understands the charges against her. This defendant understands what's being played out in court. She understands the role of the judge. She understands the role of the prosecutor. She understands the role of the defense attorney. And can she assist her defense attorney in preparing her own defense? Those are really the only issues that a competency evaluation gets into. It doesn't get into, did she know it was right or wrong? Those are the issues for the jury if it gets to that point. So competency is simply limited to, in this current state she's in, does she understand what's happening to her? Can she assist in her defense? Does she know who the players are? It's pretty limited. And states that have this process, sometimes you can be treated to competency if you're found incompetent. That's a whole nother issue. You can be held in custody and made to undergo psychiatric treatment. And then if you're treated to competency, you can stand trial. In this case, didn't even get that far. An evaluator, a PhD, probably psychiatrist, psychologist, somebody who's an advanced practitioner, said she understands what's going on. She's competent.
Let's talk about this. And by the way, in a competency, I mean, you really explained it quite well. It could delay a trial for quite some time if the defendant is not competent. But talking about the mental health of this defendant and what might have been going on, and yes, she's innocent until proven guilty, but just before the stabbing, okay, Muhammad had gone live on Instagram and posted this nearly 7-minute video, this rant that many now see as potential evidence and chilling in hindsight.
I got sent home early yesterday. I got sent home early today by the same person. I'm telling you, she's a bully. This isn't funny. She needs to understand that just because she's a mother and got children doesn't mean that she can come in this store, disrespecting people, talking to them like everybody's beneath her. She has no respect. And it isn't funny at all. Like, seriously, man, I gotta take care of. And she keeps sending me home early. It's not funny. She's playing games. And then all day, throughout the day, she keeps sending her little racial shit. And then throughout the day, she keeps on, like, putting negative energy in the air, talking about people, gossiping about people. It's not funny, man. That shit gonna have to stop. She's a bully. I'm telling you. She's a bully. She brings a lot of negative energy in there. She always panic when there's a lot going on, and then she try to manipulate that and make it seem like we ain't doing something right, but we are working really hard and doing great. It's just the fact that she panicked, and I caught her a few times making a mistake, and she tried to hurry up and play it off. You know, nobody's perfect. It's God, it happens. You know what I mean? Like, sometimes, like, somebody might get confused, so it gets busy, yeah. But she needs to stop playing like she don't be making mistakes. I be catching her.
And you could even hear her say there that her manager's behavior would, quote, catch up to her. And hours later, that grim prediction came true. I mean, if you listen to the allegations. Again, John, I just want to highlight that point one more time. Any way defense attorneys can make sure that doesn't come into evidence in a criminal case? Because if you ask me, that could be a slam dunk for them. For prosecutors.
A slam dunk for them is the way to put it. I mean, I racking my brain here to think about how you keep that out as a defense lawyer. I mean, what is it? It's evidence of premeditation, and not just premeditation in a few moments before a stabbing, but it's evidence of premeditation long before that. And we actually a couple of instances we've seen that these assassination attempts on President Trump, where the alleged assassin or the convicted assassin says things on social media about what they want to do, situations like that. We see that a lot where somebody posts something on social media. That gets back to the issue of competency, though, because if somebody is saying, I'm going to do this, are they in their right mind? If you're the defense team, you want to say, look, this is what was going on with this person. So clearly they were not stable, and you want that to feed into the issue of competency if you're trying to defend it. But at the end of the day, and in the final analysis, having a social media post where you make those kind of threats, even if it's not a specific threat, that's part of the whole, the penumbra of what you're going to present to the jury. You're going to say, look, this was set in action a long time before, and she completed the plan. So take that as a promise or a threat, and she fulfilled the threat.
Yeah, I want to go back, though, to this development in the case regarding mental health. And after several delays, there was, by the way, a review hearing in early September, while doctors completed their evaluation. Muhammad was back in court, on October 8th. And this is where the judge confirmed those findings.
The court is in receipt of a report dated September 17th, 2025. And it's my understanding that both the defense and the prosecution stipulate to the September 17th, 2025 report, which opines that Ms. Muhammad is competent to stand trial. Is that correct on behalf of the people?
That's correct, Judge.
On behalf of the defendant?
Yes, Your Honor.
Very good. So this matter needs to be set for a preliminary examination.
Now, in a statement to WJBK, Macomb County Prosecutor Peter Lucido said, the finding that the defendant is competent to stand trial ensures that she can now be held accountable through the proper legal process. The allegations describe a brutal act that has tragically ended the life of an innocent woman. Our office remains committed to seeking justice for the victim and her family. Now, John, let's get a little bit more granular here. What was that evaluation when you're determining competency? We talk about it, but what is it specifically? What are they asking? What are they looking for? How do you know for sure that she understands, let's say, the charges or the legal process or what's ahead of her? What does that evaluation actually look like?
Right. Well, it can be not necessarily, an exhaustive, comprehensive mental health evaluation. It can be an evaluator sitting in a room with this defendant and sometimes with the lawyer present, and asking just very specific questions about, do you know, starting off with things like, do you know where you are? Do you know what day it is? Do you know who's president? Do you know your birthday? Getting into things about, okay, do you know why you're here? Do you know what the charges against you are? Can you explain to me what those charges are, what you think they are? Not what happened. They don't get into any detail about the actual incident. And that's very important because the evaluator is not getting any information from the defendant about the actual alleged crime. They're just saying, look, what do you understand about your circumstances? What do you understand about your lawyer's role. Who is your lawyer? What is their job? Who is the prosecutor? What is the prosecutor's job? And who is the judge? And which person is the judge? Is that the person up on the bench wearing a black robe? What does a judge do? And it gets into those some specific areas, never touching on the actual allegation, never touching on anything surrounding that. But it's just very simple about, do you understand why you're here today? Don't talk to me about what happened, but I need to know if you can understand the context of why you're here and what could happen to you, what could happen to you if you go to trial. What does a trial look like? Who are the players? So it's somewhat limited, but in the eyes of the evaluator, they want to determine, does this person even grasp where they are, what's going on? And the people who are found not competent often have just absolutely no clue about any of these things. And that's because of the wide range of mental illness and various things that can affect the evaluation. But evaluators generally are also very well trained in trying to determine who is malingering, who is making stuff up. They can see through the any kind of falsehoods or dissembling that a defendant might engage in. So that's one of the other things. A trained, a good evaluator knows when they're telling the truth, essentially, and when they're putting on a show.
And to be clear, this may not be the end of the conversation regarding competency. There are cases where somebody could be found competent. Something happens during the course of the case, the criminal process, even maybe before trial, where there's a question of competency once again, right? I mean, what could happen? When would an attorney say, wait a minute, court, we're having a competency issue once again? What would be some red flags?
Right, and that can happen. I mean, again, if you're a defense lawyer, you have an obligation. Every state in the nation has a code of conduct for lawyers that say if you have an obligation to represent your client, and if you have a belief, a good faith belief, it can't be something you're trying to do not in good faith, something you're trying to do for the purposes of delay. If you have a good faith belief that this defendant has an issue, and it can come up again. I mean, she can be found competent to stand trial, and in 2 months, something may arise with her defense team that they say, look, this is happening again. We have a real issue. And what the competency does is it stops the clock. Okay, so as soon as it's raised, generally a judge will consider it, and if they think it's legitimate, that's another filter. A judge can say, no, I'm not going to agree to another evaluation, but that's pretty rare. The judge will stop the clock. The evaluation will take place. It can be, a month, 2 months, 3 months. But once the evaluation is in, then the judge will say, okay, we're going to have a hearing. We're going to go through all this. Prosecution, defense both get to present arguments, and the judge decides. So it can happen in the middle of a trial. It can happen weeks, days before an actual trial takes place. A lot of it gets back to the obligations of a lawyer when they believe in good faith that something's going on with that defendant.
Now, she's due back in court for a preliminary hearing on November 14th. What can we expect from that?
It's going to be your mini trial, your mini probable cause hearing, where the prosecution gets to present just enough evidence to get over the probable cause hurdle in front of a judge. It's sort of the first glance that the defense has as to some of the key witnesses in the prosecution's case. We get a lot more information at these kinds of hearings. Sometimes they get waived when the defense team decides, there's no benefit to us here. Let's just move forward. But a lot of times, if you're the defense lawyer, you're going to get a lot of discovery out of this. You're going to get a lot of statements. You're going to get a lot of information about theories from the state. So it's a valuable step. It's an important step. And especially now that she's been found competent, both sides get to see what her reaction to the evidence. And if you're the prosecution, if you're the defense, you get more information about her role in this and how she's going to respond. Prosecution gets a chance to put on their case for the first time, the first bite of the apple.
And usually, I mean, when you're talking about particularly like a case like this, prosecutors would be able to go over that hurdle and have enough evidence that there was probable cause this crime was committed and move forward towards trial. And as it moves forward towards trial, just to be clear for our audience, the potential jury in this case, they would not know about the competency issue, right? That wouldn't come up for them. That's not something they would have to use in their calculation about whether or not she committed this crime.
Right. The jurors do not hear about all the preliminary matters, including whether or not there was a competency evaluation, whether she was found competent. That is not something that they need to or will hear. That's all kept from them. Obviously, it would be prejudicial, extremely prejudicial. It could be one way or the other. So that information about competency doesn't come in. Of course, during a trial, the defense can put on various experts who can talk about a lot of things. Expert witnesses can get into these areas, but you're not going to have a jury hear about the prior competency battle or the competency evaluation.
Does this conversation we're having right now, does it give you any insight into where the defense may go? And B, it's always the defendant's choice about whether or not they want to take the stand, right? Their defense attorneys can say, do not do this. I'm telling you, do not do this, but it's up to the defendant themselves. Any idea where the defense may go with this? And B, do you think there would be any advantage for her to take the stand and explain her side of the story?
Right. As to a good question. So the defense is going to want to mitigate everything that they can. They want to be able to explain why this person reacted the way they did. They want to explain what's going on. I mean, they want to get to that. They want to get up to that line. They want to get as close as they can to the idea that she's not responsible for her own actions. And this is why. They want to establish what's going on in her head, what her mental state has been like. You know, there are a lot of reasons you're going to want to get into her history to try to give the jurors some idea of why this was not, for example, a cold-blooded killing, which the prosecution is going to be trying to paint it as. Now, as to whether she should testify, of course, that's always the defendant's choice. It's such a rare case that it's going to benefit a defendant to explain, sit there on the witness stand, look at the jurors and say, this is why I stabbed this person with a knife. I mean, that really cuts into the defense's, it undercuts the defense's claims of, look at this poor person's history, look at their mental state. When she's able to get up there and articulate things, it really minimizes any chance the defense has of appealing to one or more of these jurors. And unless it's a self-defense claim, which we haven't seen here, she's not going to take the stand.
Well, we'll see, and I'll tell you, it will be difficult for her, particularly when you have these prior statements that she allegedly made on social media, and having to be questioned about that and talk about that could be problematic. John Day, thank you so much for taking the time. It was really great seeing you.
Good to see you. Thanks.
And that is all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll speak to you next time.